you. Thank you very much.
BA LLB, Diploma in Labor Law and Cyber Law. Sir is on the panel of Bombay High Court as an arbitrator and mediator since last several years. Sir has having a practice of last 24 years and teaching experience for last 20 years. Sir has authored two books. One is on SRA and other is on transfer of property. Actually, sir has not provided any more information about him, but we all know what his practice is. So now I request Prosper D'Souza sir to continue with the lecture on the topic of Christian law. Over
Thank
to
you
you.
very much. Thank you very much for the generous words. So just a slight correction there, BALLM, but that doesn't really matter. The LLB, LLM or whatever. What matters is the information, knowledge that we are going to share. Okay, I get started right away without much ado. If there is some non-clarity, please let me know, intervene, okay, especially the esteemed Bar Council members. And I wish to thank at the outset, lest I forget later on, Dr. Uday Varunjekar and also Dr. Anbule, Rajendra Anbule, and few other Bar Council members whom I know very well. I don't wish to Chavan sir and so many others, but I don't wish to take all their names. That itself will consume a lot of time. So let me get started, as I said. We are going to look at, though the topic says Christian law, but Christian law is very vast, as in there is something called canon law also, but don't worry about all that. I will make a mention of what that canon law is as I go along. But a little bit of introduction to this law. One way of going about, I thought, would be to give a cursory look, a bird's view of the whole act. But I refrain from doing that because that itself may take quite some time, and then later on I won't be able to dwell on the specific sections. Okay. So now this law, this act, as we very well know, it is called the Indian Christian Act 1872. Okay. I mean, 1982. There were just earlier laws called the Indian Christian Act 1872 and the Indian Divorce Act 1869. So year-wise, if you see, 1872 is the Indian Christian Marriage Act and Indian Divorce Act is 1869. So divorce comes first in terms of that year and marriage comes later, which is not so. Okay. Now these two laws dealt with marriage and divorce for the Christians. No? And there was a bill mooted, for amending and codifying this law. And that bill was entitled the Christian Marriage and Matrimonial Causes Bill. That bill was pending way back in the year 1962. Okay, quite some time ago, years ago rather, no, decades ago. But then that bill did not see the light of the day, as in it did not materialize into enactment because the bill lapsed, Parliament was dissolved. Later on, the Christian marriage and divorce law, it was seen that it was outdated compared to other matrimonial laws till the amendments of 2001 came about. No? So this Indian Divorce Act 1869, that was amended in the year 2001. Okay. How was it amended? By the Marriage Laws Amendment 1. And it amended section 36 and 41. And again by another amendment, Indian Divorce Amendment Act 2001. Okay. Now, uh, uh, over a period of time, we have seen that this word Christian was dropped from the title of the act. No. Now the name of the act is the Indian Divorce Act. Whether it is a apt name, proper name or not, okay, commentaries will tell you. Ideally, it should have been entitled, it should have been amended as the Christian Divorce Act, which would have clearly given an indication what this law is all about. But as things stand, it is called the Indian Divorce Act. So be it. We are not going to spend much time on that. Okay, we move further. Now, as we go along, you all will see uh, as I was trying to revise certain things in order to deliver today, what I found is if at all there is any difficulty amongst the participants or the aspirants who would be judges, that difficulty could be with regard to understanding what the Church of England, is all about, what the Church of Rome is all about, what the Churches of Scotland is all about. So just to give you some clarification as I go along, I may reiterate what I'm saying, I may repeat what I'm saying, but at the outset, I wish to point this out, lest we fall short of time. Okay, what is the Church of England? Initially, even I thought England, matlab England mein church hoga. It is not so. No, there are churches of England in Mumbai itself. There are churches of Rome in Mumbai itself, and there are churches of Scotland also in Mumbai. Okay. Now, these churches of England, no, sometimes they are referred to as Anglican Church also. Anglican Church. This bit of information is very important, I feel, to understand some provisions, at least the definition and the subsequent provisions very properly. So again, I make a point saying churches of England are there in Mumbai, and sometimes they are referred to as the Anglican Church. Okay. To give you some examples, there is a church called Emmanuel Church, no, at uh, um, uh, this is in Mumbai itself. Exact place I don't know. But then there is this again Saint Stephen Church, which is on Mount Mary's Road, Bandra. Then there is this Christ Church at Baikala. Then there is this. Some of you may be familiar with Honeyman Circle. There is the Saint Thomas's Cathedral, no, at Honeyman Circle. All these are churches of England. The Emmanuel Church, Saint Stephen Church, Christ Church, Saint Thomas's Cathedral in Mumbai itself. All these are churches of England. Now, there's also a mention of churches of Rome. Now, just to give you immediate reference, in Mumbai, there are also churches of Rome, which are few examples. Our Lady of Egypt Church at Kalina. Then you have this Our Lady of Dolet Church at Marine Lines. Okay, then you have Our Lady of Salvation Church at Dadar. Okay, these are a few examples of churches of Rome in Mumbai. The third phrase that is used in the enactment in the law that we are going to look at, that is the Indian Christian Act, Indian Christian Marriage Act, 1982. In that, you will find churches of Scotland. Once again, there are churches of Scotland in Mumbai as well. Okay, one of them is Saint Andrews, okay, which is at Cathedral Fort. Then you have churches of Saint Andrew and Saint Columbia, which is at Talagoda and which is at Fort. So these are a few examples of churches of England, churches of Rome, and churches of Scotland in Mumbai itself. This would help a great deal, I believe so, because other things are mostly procedural. Okay, things to do with notice, things to do with maintenance of registers, and so on. Okay. As we move along, Christians are no exceptions to sending their details of marriages, under the provisions of law called Births, Deaths, and Marriage Registration Act 1886. They are not exempted from that. They too have to submit their returns. Okay. And somewhere down the line, if I forget to tell you, keep in mind that ever since this prohibition of Child Marriage Act 2006 has come about, okay, where the minimum age of a male is prescribed as 21 and minimum age of a female is prescribed as 18, that law will prevail. This law has replaced Child Marriage Restraint Act 1929. So at the outset, I made a few comments. Initially, I spoke about how this Indian Christian Marriage Act and the Indian Divorce Act, they dealt with marriages and divorces. Nowhere have I said about maintenance. Keep that in mind. Somewhere along the way, I will touch upon that as well. Am I clear in so far what I'm saying, or is there any difficulty? Am I going too fast? Hello, some feedback, some members. Is it too fast? Someone respond, please. Participant may be muted.
Sir, continue.
Okay, great. Okay. Now, as usual in many laws, though the preamble is not mandatory in any new enactment, but this act has an preamble. It says an act to consolidate and amend the law relating to the solemnization in India of the marriages of Christians. No, all these may be bones of contentions in the coming future, or other matter of discussion when we are trying to work on this uniform civil code. Okay, but now that is what the preamble says. So that itself gives us an indication that there are already laws which are existing, and those laws were not good enough, or rather there needed some changes to be made in those laws, and whatever laws were there, they were needed to be brought together, and therefore this is how the preamble is worded. So solemnization is the key word, and it talks about in India, the marriages of Christians. Then straight away, if you move to how what were the laws before and all that, you'll find uh, earlier the subject of marriage as far as Christians are concerned it was governed by 2 statutes of England and 4 acts of the Indian legislature. 2 of England and 4 of Indian legislature. No? So 2 of England were Statute 58, okay, and there is some DO3 Cap 84, and Statute 14 and 15 of Victoria Cap 40. So be it. Just get to know there were 2 statutes of England, and there were also 4 legislation in India. Act 5 of 1852, Act 25 of 1864, Act 5 of 1865, and Act 22 of 1866. These were the 4 legislation in India and 2 statutes of England. All these were consolidated, brought together, and they were amended. Now, why? Pertaining to what? Pertaining to solemnization in India of the marriages of Christian. So this present act is in a way a simplified act, no, simplified with precision, and it amends the law of marriage of the Indian Christian. The title, we have already spoken about the title. And then as far as applicability is concerned, it says it applies, extends to the whole of India, except the territories, no, which immediately before the 1st November 1956 were comprised in the state of Travancore, Cochin, and Manipur. No? If this seems to be a little complicated, to my mind, if you ask me, the initial portion of any law is very, very important. Because if you wrongly apply any law or not able to understand the applicability of the law itself, then the whole thing goes wrong. So my mediator guru would tell me, if you put the wrong button in the first button itself, if you put wrongly button your shirt, then rest everything will go wrong. So it's that way. The applicability seems to be a little important. In order to get this right, very simply what we are saying is the law as it stands today, it applies to the whole of India, except those territories before 1st November 1956 were comprised in state of Manipur, state of Jammu and Kashmir, and the earlier erstwhile state of Travancore and Cochin. So in other words, this law is not applicable to Manipur. Okay, does not extend to the state of Manipur. Okay, and also as far as there was this, what shall I say, the Pondicherry, there was this Pondicherry Extension of Law Act 1968. Okay, now initially during independence, there was this French code applicable, but after the enactment of this Pondicherry Extension of Law Act 1968, that law specified that Part 1 of the schedule and Part 2 of the schedule that was extended to Pondicherry, subject to certain modification. Okay. Now the Indian Christian Marriage Act 1870, now as in the earlier one, 1872, it was also found to be extended to Pondicherry, now Pondicherry. Okay, so it was extended to Pondicherry as well. The Kerala High Court, it happened to say, as far as the areas to which Indian Christian Marriage Act has not been made applicable, then this canon law which will apply. Initially, I did make a passing mention about canon law. What is this canon law? This is the law which was brought about by Society of Great Britain and Ireland, in association with New Zealand and Canada, or are the New Zealand and Canadian Canon Law, Canon Law Society. Once again, what is this canon law? Canon law is a Christian law. Okay, it was brought about by the Society of Great Britain and Ireland in association with New Zealand and Canadian law. Okay, Canadian Canon Law Society. Okay, that was canon law. Okay, to give you a small example with regard to retirement of priest or something like that, pujari. Okay, you'll find things given in the canon law. They go by that. And with regard to certain other sacraments, sacred things, sacred rituals, right, performed in the Catholic Church, they will refer to that canon law as well. Just to give a small example. I was talking about this Kerala High Court judgment. It says that in areas to which this Indian Christian Marriage Act has not been made applicable, there the canon law would govern the marriages among the Christians. No? So which canon law? Canon law prepared by this Society of Great Britain and Ireland in association with New Zealand and Canada. Yeah, okay, so that is one. Now, this act was not made applicable to Travancore, Cochin, as I said. and that position continues even today. Okay, and therefore, in such an event, it seems the constitution of the CSI churches, CSI churches. What is this? CSI means Church of South India. Especially some chapter 12, which deals with marriage law of the church, that will assume relevance. Okay. And clause 1 of chapter 12, that clause will authorize every bishop of the Church of South India and every presbyter and deacon who holds the authorization given by the bishop of that diocese. Now, I know I'm aware, I'm conscious that I'm using too many new words which non-Christian perhaps would not be familiar with, or some may be more familiar than the Christians even. Now, let me clarify. Now, there is hierarchy in the priesthood. Okay, there is this priest. Okay, in the hierarchy, the next perhaps would come bishop. Above that, one of them would be a cardinal, and above them, as for the Roman Catholic Church is concerned, you would have a pope. So that is kind of a hierarchy. So bishop is a little slightly higher in terms of uh, position as such. Okay. Now, with this understanding, I also use the word presbyter. Presbyter is none other than an elder or a minister of the Christian church. The word minister means a servant of the Christian church. Okay, an elder of the Christian church. That is a presbyter. Okay. Then a deacon. Okay. One who is an ordained minister. Okay, is below the ranking of a priest. So if you have to start the hierarchy once again, it will be a deacon. Okay, then it will be a priest, a bishop, a cardinal, a pope. That kind of hierarchy they would have. Once again, to repeat what I said earlier, initially I said this act was not made applicable to Travancore Cochin. This position still remains that way. And in such an event, the CSI, that is the Church of South India, especially chapter 12, dealing with marriage law of the church, that will assume relevance. And clause 1 of chapter 12, that will authorize every bishop of the Church of South India and every presbyter, that is the elder, okay, and a deacon just below the priest, a deacon who is also ordained, okay. When they are given that authorization by the bishop of that diocese is a larger area comprising of some churches, cluster of churches together, you can call it a diocese, okay. And this authority is given to these people to solemnize marriages in the church, subject to the provisions of Indian Christian Marriage Act or any other law. Okay. So all this is coming from some case law. I don't know whether the reference will be proper, but this is Santosh Kumar S. versus Church of South India District Church into bracket CSI District Church. Okay, Balaramapuram, Balaramapuram, from 2019 Kerala, from 26908. May not be so important, but in the passing, get to know that this is a little bit of background. I straight away plunge into the interpretation clause. There is always that standard line, more often than not, in the interpretation clause. Some laws will have it in section 2, some will have it in section 3. Interpretation, nothing but some kind of definition, a small inbuilt dictionary in any enactment. And that line, the line which I was talking about, it will say, in this act, unless there is something repugnant in the subject or context. That line simply means that the meaning which arises from the context will prevail over the meaning which is given in this small inbuilt dictionary in this section 3. Section 3 comprises some words and phrases which are defined there to obviate the need to repeat the meanings of those words again and again in the enactment subsequent. Okay. So the first one given out there perhaps is this. I hope you all are referring to your barrack. I wanted to put out those barrack on the screen, but I refrained from doing that, knowing fully well that each one of you is equipped with a barrack. If not, you all can always access it on your mobile as well. So the first phrase out there is your Church of England and Anglican Church. No? Mean and apply to the Church of England as by law established. No? Anglican, I told you, or for relating to the established. No? So Church of England is also referred to as an Anglican church. No? I've said that already. So Church of England and Anglican Church mean and apply to the Church of England. Now the churches, once again, at the cost of reputation, the churches are very much there in Mumbai and maybe other places in India. And therefore this law, when it was made, it also covered all these churches. Okay. Then you have the Church of Scotland, means the Church of Scotland as by law established. Okay. Now, then you have Church of Rome and Roman Catholic, mean and apply to the church with regards to Pope of Rome as its spiritual head. The church and all this religious, denomination, they are there for the religious purposes mainly. Okay. So, yeah. Going further, church, it says, would include a chapel also, chapel or other building generally used for public Christian worship. Chapel is a small building or a small room for worship. So if the church is quite big, you don't keep the church open throughout the day. You would have a small room or a small place where people can go any time of the day, especially during the daytime, and go and spend time in worship. Okay, in time in introspection. Okay, so that you would call a chapel. The church would include any chapel. Okay. To somebody who is a Christian, who is not familiar with Christian law as such, not necessarily all Christians are familiar with Christian law. Okay. For them, a church would properly mean a gathering of people who have assembled in the name of God. It will not talk about any building or any such thing. Okay, but as far as the law is concerned, here we are talking about church would include any chapel. Chapel would mean any room or some place, where people would come for worship as such. Then again, you have India. India means the territory to which this act extends. Doesn't mean the rest of the part of India is not India as such. It is, but as far as this law is concerned, the territory to which this law extends, that is considered as India as such for the purposes of this law. Then you have minor defined here, one who has completed the age of 21 and who is not a widower or a widow. A widower, one man who has lost his spouse, and widow would mean she has lost her spouse, a lady. Christian. Okay, Christian means person professing the Christian religion. There are plethora of cases on this. I will expose you all to some of them. The rest you all will find in any commentary as such. Okay. So, what do you mean by professes? As many minorities would like to claim and believe that they have been given, rightly so perhaps, that they have been given the right to profess their religion, practice their religion, okay, propagate their faith, all that. So, profess would mean affirms one faith in or in allegiance to certain religion or certain set of beliefs. Every religion perhaps would have its own ideology, own set of beliefs. So a Christian would be the one, a person who owes his allegiance or rather affirms his faith in a certain set of beliefs. I hope I'm getting across. The members, especially those who can speak because the others' mics are muted, they can anytime intervene and ask for any clarification. If I'm too fast also, you can tell me to slow down. I'm just trying to make participants to switch off your video. Okay. Yeah, voice is clear, they say. Okay. Uh, okay, I can see some chats there. Okay, fine. I should be moving on. Then you have expression Indian Christian. Okay. Now, just to take this opportunity to make it known to so many of y'all, to get certain things clear for clarification's sake. Now, I am a native of Mumbai itself. I am born in a place where I'm speaking from. I'm around 63 years old. That doesn't really matter. But the point is, I'm born and brought up here itself. And I know at least my 4 generations were Christians. So, were we converted into Christianity? Yes, surely we may have been converted into Christianity. Okay. So here, as far as this definition is concerned, the expression Indian Christian would include the Christians, descendants of natives of India, so natives of India, those who were here residing in India itself, and those who were converted to Christianity, as well as such converts. Okay. So there could be Christians there could be persons who are wanting to adopt this faith. They are made to go through certain catechesis, what they call, or they're exposed to the tenets of this faith, what the Christians believe in, and it could be a long process, 1 year or even more than that. And at the end of it, they are free to say they don't wish to become a Christian, and the authorities are free to say that you really don't seem to be wanting to be a Christian, so please don't be one. So that is how it is. No, suddenly somebody doesn't become a Christian. It may be happening in some denominations. Okay, there are denominations and denominations. Okay, somebody who has access to Bible, he claims himself to have formed a church in some place somewhere, and he will perhaps convert people saying now you're a Christian. But that is not what the larger church, the mainly Roman Catholic Church as we know, and the Protestant Church, which are two big denomination kind of, they will talk about. Okay. So just for some clarification sake, I'm saying all these things. Okay. So moving further, then you have this Registrar General of Births, Deaths and Marriages, would mean Registrar General of Births, Deaths and Marriages, appointed under the Births, Deaths and Marriages Registration Act, 1886. Okay. So there is this word which you may come across, okay, called episcopal. If at all you come across some such word in your uh, any of the commentaries, okay. So where they have the authority which is uh, higher than the what did I say? Higher than the priest, the bishop. No, they're governed by bishop kind of government of the bishop. They have the bishop. No? So episcopal would mean of a bishop or bishops. No, church which is governed by or having bishops. In short, that would mean episcopal. Okay. England church refers to Christian churches in Anglican tradition and all that. You would have bishops there. So that is a designation which the priestly persons would hold. Minor, I've already said. Definition of minor differs from the definition in Indian Majority Act 1872. Unfortunately, we teach contract law in many law colleges, but then we don't have the time for us to tell them to look at Indian Majority Act 1872. A few sections, there are hardly 4 or 5, and help ourselves. But the definition out there and this definition differs. Okay. Now, a person who has not completed the age of 18 is a minor under that act, okay, regardless of his marital status, irrespective of whether he is married or not. But that act does not apply to the subject of marriage, adoption, divorce, and dower. Okay, dower is a concept in Muslim law and all that. For these matters, the age of majority has to be settled by the personal laws. I'm not giving the citation or any such thing, but that is how things are. As far as the personal laws are concerned, age of majority will be governed by a personal law. Okay. Now, once again, clarification of who a Christian is. As I said, there are plethora of cases. Initial portion is very important. Subsequent sections are all about procedural things that can be easily understood if this initial portion is grasped properly as such. I've already overshot my time, or rather, there's so much to capture. Okay. Now, the Orissa High Court, for a Christian who's not familiar with Christian law, for him there is a what we call a vidhi, a sanskar, no sacrament, something sacred. That is called baptism. Just as we say munja vagare, similarly a sacrament of baptism. For a normal Christian, he will say, if you're not baptized, you're not a Christian. But then you have case laws, not one, so many of them, right from Orissa High Court to other high courts, saying that the person who professes the Christian religion may not be baptized, yet he would be a Christian for the purposes of this act. That is one of the case laws. Anybody interested in a citation, it is KGB David versus Nila Moin Devi, Nilamo Devi, some AR 1953, Orissa 10. Somebody wants a case law later on, I will put it in the group. Don't trouble yourself too much if it is too much to understand at the same time and write down. Okay. Moving on further, Allahabad High Court, it held that one doesn't become a Christian unless he professes the Christian faith. I told you what professors mean. You owe allegiance to a certain set of beliefs. You are professing that faith. No? Therefore, though a person may have been baptized, what is baptism? Baptism, yeah, I can see something on the chat. Baptism is the vidhi, a sanskar. Okay, one of the first sacraments, the first sanskar. The Christian church mainly believes in 7 sacraments. One of them is baptism, you have Holy Communion, you have confirmation, you have marriage, you have holy orders, and so on. Somebody who takes the oath of a priesthood, there are 7 such sacraments. Okay, now that initial sacrament, when you have to be initiated in the faith, now, mother may be Christian, father may be Christian, or one of them may be non-Christian. If they want the child to be brought up in Christian faith, they would approach the church authority, the priest, and they would say, kindly, we want to bring the child in Christian faith, therefore baptize him. So in the name of God, in the name of Jesus, they will pour holy water on his forehead and they will bring him in the faith. And they will take a promise from the parents, some kind of oath, saying that they will bring the child in that faith. That is voluntarily. If they don't wish to bring the child in Christian faith, that's fine. A person married to a non-Christian is never ever forced to bring the child in Christian faith. It is the decision of the couple, not just one of them. Both of them would decide how they want the child to be brought up. Some choose not to baptize the child. not to bring up in Christian faith. Some will just want the child to know about the Christian faith and later on decide for himself. So when he's adult also, he can receive that baptism. But only thing when he's adult, when he becomes big, he can receive this baptism as well as other two sacraments called communion, where they say Christ's body they consume so that they become like him. Okay, symbolically kind of. They really believe the presence of Christ in that uh, host, what they call. Okay, and a confirmation. Confirmation is when a child reaches a certain age of reasoning. Okay, he is then told to decide for himself whether he wants to continue in that faith or not. So baptism would have happened when he is in the womb, an infant. That when the parents take a vow on his behalf. When he grows up, that is the time when the child himself, when he has reached the age of reasoning, he himself will say he wants to continue in the faith or not. He's got a choice. Where the parents don't have any say. Okay, Holy Communion is. Somebody wants to know what is Holy Communion? Is it? Holy Communion is Christian belief that Christ had died for them. He shed his body, he shed his blood for the salvation of Christians. And so Uddar Bhava Manu. And that what he did years ago, 2000 years ago, that is enacted and it is realized, actualized, once again made real. His presence is made real in a sacrament called Eucharist, not sacrament, it's a Holy Eucharist, Holy Mass, which some may be familiar with, which is celebrated in the churches. Okay. Citation I will give you, Ms. Sunidhi Sagre. I will put it in the group later on. Don't worry too much about it. We may lose out some time on that. Okay, I am telling you generally about these sacraments and about these things. Still, if there is doubt, you can insist on getting to know further. Clergyman is nothing but a priest. Yeah? Someone we call pujari in Hindus. So he would be a priest in clergy is nothing but a priest. Okay, clergyman. They are called clergy. Okay. Yeah. Okay. I'm moving ahead. Now, Madras High Court, if somebody is, let's say, excommunicated, he acts against the precepts of the church, okay, and the authorities of the church don't like his behavior or his conduct for some reason given in canon law or some law, they think that this person should not continue to be in the Catholic Church. They excommunicate him, they throw him out of the church. Yet, the case law says, even if he's excommunicated, if he continues to profess the Christian faith, if he still believes in that tenet, not tenets, belief. What are those beliefs? Forgiving others. What are those beliefs? Serving others, serving mankind. Those kind of beliefs are there. There are certain other beliefs also. Believing in Christ, believing in God, believing in the Holy Spirit, all of that. So when a person believes in all of that, then he is certificated. If he continues to believe that, even though he may have been thrown out by the church, yet he would be a Christian. This is a full bench decision of the Madras High Court. Okay. Moving on. Sometime back they felt that the definition is not adequate enough of a Christian, who a Christian is. And there were therefore two law commission, one 15th and 22nd reports came up of the law commission, and they felt those reports clarified that there was no need to modify the definition. The existing definition was good enough, and that's how the definition remains as it is. Okay. Now, uh, the religion of a child would be same that of a parents, but if that person or any of a descendant that deconvert, he would be no more be a Christian. Deconvert, somebody would call it ghar wapisi kind of. Some people would say they have become Christian now. They should only if they were Hindus or whatever faith they belong to. So that kind of thing happens. There's a case law to that effect. Many would perhaps be interested in knowing that case law is Martha Ma versus Munnuswamy, AIR 1951, Madras 888, AIR 1951, Madras 888, Marathama versus Munnuswamy. So if a person chooses to go back to some other faith, is free to do that. Nobody forces anybody to remain in any faith. That is my understanding, and this is borne out by this case law as well. So this is very old case law, still it holds good. Okay. Then you have the Indian Succession Act 1925. Unfortunately, many law colleges are not able to spend much time on this law, because when they teach you family law, they teach you Christian Act, they teach you Muslim law, they teach you Parsi Act, and by the time the semester is over, no, so not much time is they are able to devote. Some colleges may be managing to do it, but Indian Succession Act also defines the word Indian Christian, and there it is defined as a native of India who is or in good faith claims to be of unmixed Asiatic descent, one were descended, okay, and who professes any form of the Christian religion, any form. No, so there are divisions among Christians also. Some believe in some kind of set of belief, but the core belief perhaps would remain the same of many Christians, perhaps depending on what they really believe. Okay. Now further on, uh, one who wants to become a Christian, there are case laws on that also. Person who is admitted to baptism, it is a sacrament which I just told you a little while ago. He should have manifested his intention, his mind, his icha to receive that baptism, that sacrament of baptism, no? And he should be adequately instructed in the truths of the faith and in the duties of a Christian and tested in Christian life over the course of catechumen. Catechumen is a period, a time, not less than 1 year. Okay, earlier it used to be much longer. So during that period, that person is told a lot of things about the church and is told to make a reasoned choice, okay, and he's given that freedom to get up to choose whether he wants to be baptized or not. So that is what it is. And where the baptism ceremony, this particular ceremony is conducted as an empty formality, just for the sake of it. Everybody comes, you just pour water and say you're a Christian. No, that will not be any good. No, that with that empty formality happening, there is no conversion to Christianity at all. No, uh, one may, or rather, he will be regarded as having continued in the old faith as such. Okay. Then now further on, under the canon law, there is some case law. Uh, some division in the church. Some priest has performed some kind of marriage. Okay, there is some division seized by the schematic priest. No, where the parties to the marriage are Roman Catholic, parties are belonging to the Church of Rome, Roman Catholic, where they regard Pope as the head. That will not be recognized as valid by the Catholic Church, and the offspring will be declared as illegitimate. No? But as far as Section 4 and 5 is concerned of the Act and the progeny, they are perfectly legitimate. As far as the law is concerned, they are perfectly legitimate children. Church will have its own way of going about. Now, let me give a simple example, lest we fall short of time. As far as divorce is concerned, the Christian church will not believe in divorce at all. At the most, they will declare the marriage null and void as if it never happened, going by the facts of a case. No, the divorce act, when we deal with it, we'll talk more about it. No, church has its own way. But for the church very much recognizes the decree granted by civil court, and it cannot ever say that the decree which is granted by civil court, we are not accepting. No way. So the church may have its own tribunal, no, but that tribunal decision will not prevail over the decision of a civil court. And this is the little bit extra detail for those who may not be knowing much about this faith. Now there is something called announcing of bans also. Just as we bear a ban, okay, advocate. Now here there is announcement of BANNS. Okay. A mixed marriage, if it is celebrated, now for your information, if a boy is Christian or a girl is Christian and the other spouse, would-be spouse is of other faith, still the marriage can be performed in a church, but only thing they will not be given certain that Holy Communion, what I said, baptism, that they will just be around when the marriage is taking place. But the marriage will be blessed. But that certain sacraments which are given only to a person who owes allegiance to the professor that faith, to the set of beliefs, only he will be given. So if a person chooses not to get converted, still he is not refrained. As a matter of choice, he can still, if he wishes to get married in the church, he can get married. No? Of late, there is a trend for people to get married before the registrar as well as in the church. So something sacred, so church will take care of it. And for the purposes of law, your passport sake and other purposes, they'll want to fulfill that formalities of getting married before a registrar also. Though they may not be necessary, but church certificate will be as valid as a marriage registrar because that can be endorsed, okay, in Mantralaya before the registrar. And for the formalities after it is completed, that will be considered as a Hello? Can you hear me? Can you hear me? Hello? Can you hear me? Okay, okay. I'm so sorry, something, there was some technical glitch. I continue. Okay. Now, if the marriage between two persons, okay, if it is solemnized by following the procedure which is laid down in this act, no? Only then you can invoke the provisions of this act. I don't know, I'm not very comfortable. I'll just try to put a... One moment, just be around. Yes. Now, if there is the wife of a Christian, okay, by birth, or rather, if the wife is a Christian by birth, but the marriage with a Hindu that was not solemnized as per the provisions contained in the marriage solemnized outside church, whether it is recognized, yes, subject to certain provisions. If you're not within 5 miles and you're given permission by the authorities to perform the marriage outside the church, then that is also recognized marriage as such. But ideally, for in the understanding of the Christian mind, a marriage has to perform in amongst the assembly of people. The people should be there. It is something which should be blessed by the people as well. And certain prayers to be recited to make that marriage sacred. So there has to be presence of the people. It cannot be done in a private room where there are just 1 or 2 persons. Okay. Have I clarified your doubt? Have I clarified your doubt? I guess so. If not, please put in the chat. I'm on my mobile. I won't be able to. Okay. Now I move on. Now there are case laws which will tell you if the baptism is an empty formality, then that marriage is null and void. Subsequently, you're getting married as a Christian, but the baptism was performed only for the namesake. It would not be regarded as a Christian marriage as such. Okay, let me move on. Now, who performed the marriage? If you move on to section 5, it should be solemnized. Okay, by whom? Person who is receiving episcopal ordination. Already clarified what that word episcopal means. Okay, there are bishops and all that. So episcopal, I've already said that. Provided that the marriage is solemnized according to the rules, rites, ceremonies, custom. These rites, rules, ceremonies, rituals, they help facilitate in solemnizing that marriage. Okay. Then again, the clergyman is a priest of the Church of Scotland. Provided that marriage is solemnized according to their rules, rites, ceremonies, and custom. Then the minister of religion, licensed under the Act to solemnize marriages, then by or in the presence of a marriage registrar appointed under this Act, some lay person to be appointed as a registrar, okay, or by any person licensed under this Act to grant certificates of marriage between Indian Christian, that is section 5. Okay. What do you mean by solemnization? Solemnization means to perform the marriage according to rules, rites, rites, ceremonies, and customs of a Christian church. Okay. So if a marriage is duly solemnized by the minister of a church, according to the provision of 5.1, it is a valid marriage, and the decision of the tribunals could be whatever, but the civil court's decision will prevail. You may want to note this: JOSE versus Alice, ALICE, 1989. Jose versus Alice, 1989, Criminal Law Journal, 1527, page 1527. So why is the tribunal at all there? It is to guide the people, help the people, counsel them, try to patch up marriages, see where the problem lies. But they will also advise them to go to the civil courts if they want any such orders from the courts, be it separation or whatever. Be it maintenance also. No tribunal has those powers to grant maintenance or declare marriage as parties are divorced as such. In my experience, I've come across people who have gone and got an affidavit from some notarized affidavit saying that we are divorced now. that is not recognized by any tribunal, any church, one has to get a proper decree of a civil court, then it will be binding. Okay. So another one, Division Bench of the Guwahati High Court. It was held in some case. I'm not giving the citation of each and every case. They said that there can be no marriage by mere long cohabitation. So that living kind of thing, if you are living for a long time, that itself does not make it a marriage as such. Okay. No. And women in that such a relationship would be regarded as a concubine. And she would have no civil right when discarded by a or other paramour and all that boyfriend discards her, then she would have no civil right. Now, this for information, this is a very old case. Now times have changed. We are looking at new things happening in the society. Yeah. Okay, I can go a bit slow. Trying to race against time. Okay, yeah. I surely can go a bit slow. Yes. So I'm saying you are simply cohabitating, what we call living relationship in today's time. But earlier time you would cohabit. That would not be good enough for you to claim that you are a married person. Yes, CRPC 125 certainly applies to Christians. The whole of CRPC, the whole of criminal law applies to Christians without any exception. No, neither have they claimed exception, nor can they be granted any exception. They are very much Indian citizen and they have accepted all of the laws of India as such. So much so that when this Christian Act came about 1872, you found that the whole lot of procedures and all that they were in keeping with. They have to submit their returns to birth, death, and marriage registration as per the Birth, Death, and Marriage Registration Act, 1886. They have to submit returns. All of that remains as it is. Okay, they are not exempted from all of that. Though earlier, some years ago, the passport office would recognize a marriage certificate as valid or a baptism certificate also given by the church that would serve the purpose for issuing a passport. But now, no more. They don't regard baptism certificate and marriage certificate as such. They will want other documents, a birth certificate and such other documents. Okay, living certificate. Moving on to grant and revocation of licenses to solemnize marriage. No? The state government has the power as far as the territories under its administration. Okay, they will come up with a notification as in so many other cases, and they will grant license to a minister of religion for what? To solemnize marriage within those territories, no, or to revoke marriages, no, maybe by like notification or other, sorry, not revoke marriages. They can revoke a license which is granted also. The state government has power to, within their powers to empower somebody to solemnize a marriage, or they can revoke that license to solemnize a marriage also. Moving on further, 7 will talk about state government could be appointing one or more Christians either by name or by holding any other, it says office for the timing. So by person name or by the office that you hold to be the marriage registrar or registrars. Okay, there could be more than one registrar, senior most registrar. One of them would be a senior registrar. State government would appoint him. So, okay, when there is only one registrar, if that person happens to fall ill, yes, by all means, Tanmay Shindeji, by all means, Domestic Violence Act also applies. You talk of any damn law, it applies. Okay, without any reservation, without any hesitation, indisputably. Okay, it applies across to all Christians without any exceptions. Unlike maybe or other faiths which may be claiming to be governed by the personal law, but no. Only far as this marriage is concerned and divorce is concerned, you have special laws enacted for them, and they're governed by those laws as such. Okay. So, as I was saying, if there is only one registrar appointed, if God forbid, if he falls ill or is absent or that position is temporarily vacant, then the magistrate of the district will have the powers to do the needful during the absence or illness or temporary vacancy of that marriage registrar. Moving on to section 9, that is about licensing of person to grant certificates of marriage between Indian Christians. No, so as we said, that license state government can grant either by name or by virtue of that office, and that person will be authorized to grant certificates of marriage between Indian Christians. So also license which is granted to be revoked by the authority, and every grant would be notified in the Gazette. Without notification, there is no proper grant as such. Then you come on to the time for solemnization. Already there was a question on that. So every marriage would have to be solemnized between 6 in the morning and 7 in the evening. But that is not, that's it. There are provisos to it. There's an
exception. The first one will talk about Church of England. As far as that is concerned, they can have their marriage at any hour other than between 6 in the morning and 7 in the evening. Okay, other than what we are saying. So other than between 6 and 6 a.m. and 7 p.m., they can have their marriage. Okay, so under the hand and seal of the Anglican bishop. So bishop, the authority above the priest who has many churches under him. Of the diocese is a larger area under which there are many churches, or his commissary, whatever authority is given. Under that, he will decide. Because this, I believe, this provision may have found its way into this enactment, perhaps because of the time zones, different time zones in England, different time zones here, different time zones in Scotland, in Rome. Maybe because of that, people may be wanting to get married at some other time other than 6 in the morning and in between 6 and 7 p.m. So other than that, because this time zones, difference in time zone, this provision may have been made. These exceptions rather. If also marriage in the Church of Rome could be between the hours of 7 in the evening and 7 in the morning, what we call night year. Because if you have received a general or a special license, okay, in that they are from the Roman Catholic bishop of the diocese or the vicariate. Vicar is again a priest. Vicar, a priest. Vicar, V-I-C-A-R. Okay, vicariate. In which such marriage is to be solemnized. Okay, or from such person as the same bishop is authorized to grant such license. Okay. So this also information may not be revealed in many books. That's for information. Marriage mostly takes place in the girls. Girl is from, let's say, talking of Mumbai. Boy is from, let's say, Dadar. Girl is from, let's say, Grand Road, somewhere that side, or from Andheri. Then marriage would ideally take place in the church where the girl resides, ideally, to make it perhaps convenient for her. But that is not necessarily so. If exemption is granted, permission is granted, they can have that marriage performed in other places. Okay. Yes, Indian Succession Act also applies. Yes, it does. It does. Okay. In fact, of course, there are different slots for Parsi marriages, different slots for Indian Christians, as far as personal law is concerned, property law is concerned in Indian Succession Act. So each one has this, how much share will go to the children and all that. That is in place. Okay. Yeah. Then you have, please, if I missed out on any question, you're free to ask again, because now I see that the chat is propping up. Okay. Then the clergy of the Church of Scotland solemnizing marriage according to the rules, rites, ceremonies, and customs of the Church of Scotland, that also falls within the exception as such. I've given you some kind of reason for it, though the books are silent on the reason, but perhaps that could be it. Okay, how property disposal under Christian law. No, as far as these two laws are concerned, we are on Marriage Act and we are on Divorce Act. Divorce Act we haven't touched as yet. These don't talk about property. Property law, you'll have to go to Indian Succession Act 1925. Is that clear? There are provisions there with regard to how the property interstate will devolve, okay, by operation of law. Yes, Section 125 will surely apply. It would apply. Yes, it would apply. In fact, neither this Marriage Act nor this Divorce Act talks about maintenance. So Section 9 of CPC, any civil right, okay, in civil nature and all that, you can agitate in a civil court. Custody of children, no, all that is separate laws. Okay. Yeah. So civil law, you can avail the civil law over and above this. This is, as we said, the preamble gives you a key to open the minds of the legislature as to what is in the mind of the legislature to consolidate to foreign laws for Indian enactments, all of them consolidated together, and to amend the law with regard to solemnization of marriage. This is restricted to solemnization of marriage. Now you move on to Section 11 that talks about, so no clergyman of the Church of England shall solemnize a marriage any place other than the church where worship is generally held. So take it from me, various sacrament, be it baptism, be it communion, be it confirmation, be it somebody wanting to be a priest, wanting to get married, whatever, or funeral, everything has to happen in a church in the presence of an assembly of people. Okay, it cannot be happen in a private gathering where just one or two people are around there. Technically, that may be right as far as the law is concerned, but ideally, expectation is that it should happen in a general, generally a place where worship happens, according to the forms of the Church of England. Unless there is no such within 5 miles and all that, by the shortest road, okay, unless he has received a special license authorizing him to do so, all that we have dwelt upon. Then for the special fee would be charged. All these fees are very nominal, by the way. No, the register of diocese, a larger area within which there will be so many churches, okay, they may charge the additional fees. Moving on to section 12, the notice of intended marriage is there. Whenever marriage is intended to be solemnized by Minister of Religion, okay, license to solemnize marriage under the one of the person, he would have to give a notice in writing. No, why this notice? If you understand the intention of the legislatures, yeah, again, your Indian Succession Act, daughter's right and all that, everything is there. So at par with boys, par with male. Indian succession will deal with it. This law pertains only to marriage. Okay. So yeah. No, that's fine. That's fine. That's fine. Because they may only be concerned with clarity on certain questions. Rest they may be able to grasp on their own. So notice, what is the intention of notice? So that anybody has any impediments, any objection to that marriage, they'll bring it to the notice of the pastor, the church, the cleric, the clergy, the priest, no? And that marriage, if it is found within close relatives and all that, they will not then allow that marriage to happen. Okay, therefore this notice, no, a person is already married, online stuff. I know of some person who had come to me, that lady was nearly saved. Last minute she changed her mind. And then she was about to get married to somebody who was already married, a Christian though, already married. And this lady didn't know. So she got to him, she got to chat with him online. And she was under the impression he's not, he was never ever married. So all these notices and all that are required for that. No form is given in Schedule 1, notice for form, or to the like effect. The form is not so important. The contents are, or to the like effect. To the minister of religion, notice would have to be given to him. And then notice would have to have certain information, obviously to serve the purpose, name, surname, dwelling place, where you stay, during which each as well, how long you stayed there and all that, church or the private dwelling, in which the marriage is to be solemnized. Okay. If either of the persons that dwell there, 1 month or upwards, all those information is to be given. Then the notice would have to be affixed in the conspicuous part of the church, conspicuous, where nobody can miss it out. Over and above that, as I said, the banns, BANNS, banns. Ban is the announcement made in the church during the what they call the Holy Mass, which is celebrated surely on Sundays and other days as well. So the notice is read on Sundays. Okay, only after 3 bans and all that, they would have their marriage solemnized. So that enough opportunity is given to whoever has any objection to those marriage. Then there is the publication of notice. Okay, section 13 we'll talk about it, to be affixed in conspicuous part. 2 or more marriages, certainly not. 2 or more marriages are not valid. In fact, this divorce also was never ever permitted. But the church believes in going by the civil laws, and it doesn't contradict the civil laws which are prevailing in the country. Okay, though it may not be okay with a divorce, but if the divorce is granted by the civil law, they have to accept it. They have no choice there. 2 marriages, 3 marriages, not at all permitted in Christianity. In fact, it believes in the sacredness of marriage and the indissolubility of the marriage. Once married, you're married forever. No, so it is a not tied till death does them apart. That is the belief of the Christian church. Okay. If the person is not entitled to officiate on the marriage, no divorce in Christians. No, technically speaking, no divorce. But there is the Divorce Act which is there. Okay, that permits divorce. But as far as Christian church is concerned, they will not believe in divorce. I hope I'm able to bring that distinction very clearly. Okay, but they will always respect the decision given by a civil court, and it is binding on them. Have I got myself across properly? Then if the note, yes, if the notice is given to a minister who is not authorized to officiate and all that, he will return the notice to the person who delivered it, or give it to the minister who can officiate. All that is simple and easy to understand. Okay, once again, notice of intended marriage in private dwelling. Again, near the private dwelling, it would have to be affixed at some conspicuous part, obvious reason. Then there are provisions with regard to minors marriage. Okay, when you receive that notice within 24 hours, you have to return the same under provision of 13. I told you that Prohibition of Child Marriage Act 2006 will prevail. Keep that at the back of your mind. So to that extent, this law has become 40 years. Okay. Important section, it's difficult to predict any important section. But to my mind, this initial portion, if understood properly, rest is just a cakewalk. You can just understand it by cursorily even looking at it. memorizing word to word may take some time, but understanding part of it will come very easily if this nullity of marriage will come to the Divorce Act when we will talk about it. As of now, we are talking of solemnization of marriage. Okay. So, yeah. So then we move on to 16, section 16, procedure when the notice is received. Okay. Then also, mind you, marriage is taking place between parties staying within the jurisdiction. Either spouse passed away earlier than second marriage. Yeah, they are entitled to second marriage because he is as good as now without a spouse having died. Okay, even a person with divorce is entitled to get married. Okay, the church will not generally want to, church has no problem with it. The civil court allows this marriage. They go before a marriage register. They get themselves married. The marriage is blessed. That's fine. Okay, there's no difficulty there. Okay, so but adultery and all that, or bigamy and all that is certainly not allowed. Okay, then once again, procedure part is on receipt of notice. Okay, so I was saying if there are people saying in two different jurisdictions, then that notices they are like both the priest of the churches will know that this person will get married to girl of that parish, or this person will get married to boy of that parish. So there'll be bans announced in both the churches. All that is there. Then certificate of issue of certificate of notice given and declaration made. Any minister of the religion who's consenting or intending to solemnize, if he is required to do so for and on behalf of the person to whom the notice was given, he will, and upon one of the person intending marriage, making that declaration, will issue a hand certificate of that notice having been given. So notice is received. He will say so, and that certificate will be issued. He will not issue it until 4 days after the date of receipt of the notice. And if there is no lawful impediment, only then he will issue that notice. Then issue of that certificate will not be forbidden or has not been forbidden in manner herein after mentioned by any person. If it is forbidden in any manner, bandi asel, kontai prakachi, artha asel, he will not issue it. Then you go on to section 18, declaration before issue of certificate. So there is the declaration. They have to say he or she believes that there is no any impediment, person, self-declaration kind of any kindred or affinity. You cannot get married to your own sister, first cousin, and this and that. For scientific reason also, and because the church also does not allow such marriages, the law also comes in the way. Or either or both of them or the parties or minor or minors, all that is there. Or the consent or consent required by law that is not obtained. Okay. So those restrictions are there. Then you have consent of father. First the consent of father, then the guardian, then the minor. Father is not there and things like that are there. Don't ask me why. It may be sounding little not right. The law perhaps does not sound proper as such. Why the father is given preference over the mother and why the guardian and then the mother. It is always questionable, and there can be discussion taking place on all this question. But the law as it stands today, section 19 would talk about father if living for any minor, or if the father be dead, then the guardian of the person of that minor. Case there be no such guardian, then the mother of that minor can give consent to the marriage. Okay.
Hello, sir. Am I audible? Yes, yes. I'll ask. Please unmute, sir. Please unmute D'Souza, sir. Sir, just a minute. Hello. Please, D'Souza sir, unmute kara, sir. He is also here. Please unmute him. Bagul sir, please, D'Souza sir, unmute kara.
Okay,
So we are so
thank you so
sorry.
much. I think I'm exceeding my time. Can I go on for a little more while? Or am I trying the patience of audience?
No, sure, sir. You can go ahead.
Okay, okay. You let me know when to stop. I don't mind continuing because I would be having another session also to complete some.
Yes, sir. Yes.
So let
Yes, sir. You will be having another lecture as well.
Yeah.
So if you had divided it already, then
little
can-
more time. Should I say little more time I get? Do I get little more time today? 5 minutes maybe?
sure, sir.
Yeah.
Yeah,
So
sure.
people will be having their own commitments. I don't know. Okay.
Yes.
So we were somewhere on section 13. We spoke about publication of the notice and all that. Yeah. Okay. Then I said he has to transfer that notice to some other minister and all of that. We have spoken about that. Then we move on to section 16 also, 17 also. Then we spoke about 18, declaration before issue of certificate. Person has to make a self-declaration with regard to there being no impediment, with regard to kindred or affinity and all of that. No? So if it's a minor, then we move on to 19 also, where we spoke about consent of father, then the guardian, then the mother. Then there is 20, power to prohibit by notice issue of certificate. Okay. So one who has a right to give consent, he can prohibit the issue of certificate by a minister. So father has a right to give consent, after him the guardian, after him the mother. They have a right to stop him from giving a notice, okay, giving a certificate as such. Then 21, any such right is violated if there is no remedy in law, always you can move the High Court. Okay. So, or in the metropolitan cities or the district court. Then you have section 21, procedure on receipt of the notice. Solemnize the marriage until he has examined the matter of the said prohibition. Somebody saying he's of close kindred or affinity, whatever. He has to examine that aspect. Only if he's satisfied, then he would go ahead. No? So otherwise, he has no lawful authority to go ahead and issue that certificate as such. Then you issue a certificate in case of minority. Okay. The minister is not satisfied that the consent of the person under section 19 has been obtained, then he will not issue that certificate, as I said, until the expiration of 14 days as such. Then section 23 will talk about issue of certificates to Indian Christians. Okay. Before issuing certificates, he has to take cognizance of the purport and effect of that said notice or certificate as the case may be. And if not, shall translate. So person has to know. I'm not getting voice. What shall I do then? I don't know whether I'm audible to others. One participant saying I'm not getting across. So if that notice is not clear, it would have to be translated or cause it to be translated. No? So into some language which a person understands. Yeah, right. Thank you. So then there's the form of certificate given in Schedule 2. Then you have section 25 talking about solemnization of marriage. So after that issue of certificate, according to the form or ceremony, as the minister may think fit to adopt, there could be slight variations of the forms. Okay, that doesn't really matter. That doesn't vitiate the marriage as such. Okay. There'll be some case law which will tell you there is some issue with regard district petition to be filed in district court, US petition. Yes, family court. Only Parsis straight away High Court. Okay, we'll come to all the divorce later on. Okay. Yeah, divorce will come later on, all the judicial separation. Hold your guns, we'll hang on for that. Okay. So if within 2 months the marriage doesn't get solemnized, then you would have to issue a fresh notice as such. Those provisions are there in 26. Then you have 27. Marriages when to be registered. Okay. So if they are solemnized in India between persons, one or both of whom professes the Christian religion, except marriages solemnized under 4, 5, or 6, that is the subsequent parts. Okay, part 5 or part 6 of this act, they shall be registered in a manner herein after prescribed. Okay, so that is what it says. Then you have section 28, registration of marriages, which is solemnized by clergymen of Church of England. Then again, you have that form set forth in the 3rd schedule. So that you'll have to go by that form as such. Then you have quarterly returns to the archdeaconry, okay, archdiocese, place and area. So number of churches covered in that area, they would have to file returns, quarterly returns as such. Okay, so 4 times in every year, in duplicate, authenticated by the signature, entries of my register marriage. Mind you, as far as I can vouch for this, or my knowledge goes over the years I've seen, not one minor change will be made in any of the certificates issued by the church, be it baptism certificate, be it confirmation, be it your marriage certificate. एक word भी इधर रुका उधर नहीं कर सकता वो, no? They never ever do it. No? So yeah, then quarterly returns are to be filed. You know? So we have said in duplicate, authenticated by the signature, entries of the register of marriages and in place, whereas in a spiritual charge, all these spiritual heads are for spiritual charge as such. And when this has to go to the registrar of the archdeaconry, to which is subject or within the limits of it that place is situated. What will be the contents of that returns? No? From 1st January to 31st March, that is one slot. April to 31st June, another slot. July to 30th day of September, and from 1st October to 31st day of December. Those are the different slots for which returns are to be filed. They have to be sent by the clergyman within 2 weeks from the expiration of each of the quarters above. So they are also bound by law. Okay. Cancellation of certificate, no. Court can cancel it. Once you issue it, you cannot tamper with it. It does not have a power to recall it as such. Okay. Then the registrar, upon receiving those returns, you will send one copy thereof to the Registrar General of Births, Deaths and Marriages. Then you have section 30, register and returns of marriages solemnized by clergymen of Rome. So once again, he has to, that marriage is solemnized by the clergyman, the priest, the Church of Rome. It has to be registered by the person according to the form directed. The Roman Catholic bishop is above the priest. Of the diocese, a larger area, or vicariate, vicar is a priest, vicariate, the jurisdiction within which that is happening, in which said marriage is solemnized, then that, and okay. Yeah, then that such person will forward quarterly returns to the Registrar General of Births, Deaths. All this is procedural, as I said, rest can be easily understood. Then you have section 31, talking about clergy of the Church of Scotland as such. He also has to keep a register of marriages according to the 3rd schedule, tabular form given in the 3rd schedule. Okay. Every marriage is solemnized, he has to incorporate in that. He has to forward quarterly return to Registrar General of Births, and similar to those prescribed in section 29, you have that. Section 32 will talk about certain marriages to be registered in duplicate. All this may found repetition because we have seen different churches there. All these are formalities. Immediately after solemnization, he has to register that marriage in duplicate, okay, or rather by the person solemnizing the same. Okay, he has to keep a registered book for that. Okay, And the fourth schedule is spoken about here pertaining to section 32. I'm moving ahead very fast because there's not much to explain there. Okay, then you move on to section 33. It talks about entries of those marriages to be signed and attested as such. Okay, who signs? The person who, mind you, when the marriage takes place, you would have the spouses signing them, you would have two witnesses from either side signing them, and you have the person who is solemnizing that marriage, he also would sign that register that such. Two credible witnesses. Doesn't really matter if both are women or both are men. One is man, one is woman. Doesn't really matter. Okay. So, and those entries have to be made from the beginning to the end of the book. You cannot leave out any pages for any manipulation as such. No? And number of entries will have to be corresponding to the entry in the marriage register as such. 34, we talk about certificate to be forwarded to marriage register, copied and sent to Registrar General. Within 1 month, that has to be done. Okay. Then you have 36 talking about registrar will also add the last mentioned number of entry in the copy of the book so that he is given no scope for manipulation as such. And every month, what was the previous entry, last entry, all that we have to mention. Then you have section 37 talking about registration of marriage between Indian Christian person referred to in certain clauses there. Okay. So he can, instead of proceeding as per section 28 to 36, he can register the marriage in a separate register book and has to keep it safely until it is filled. Or if he leaves the district before the said book is finished, he'll make over the same to the person according to his duties. So handing over of the charge. Yes, witnesses are absolutely necessary. No, as far as this Christian marriage, has two parts to it. One is the contractual part to it, and one is the sacred part to it, the solemnization part to it. Okay. Unlike Muslim marriage, which people generally teaching law and learning law, they regard it as a civil contract, purely as a civil contract. Though to my mind, it is not exclusively or purely a civil contract. There also some kind of prayers are recited, and that occasion is also made solemn. But that apart, that is not our area of discussion now. Witnesses are a must as such, without which there cannot be a valid marriage. Okay. So, yeah. If there is one or more registrar, then it goes to the senior marriage registrar, that custody and disposal of registered book. Okay. And he will send it to the Registrar General. All procedural things are there. Section 38 will also talk about notice of intended marriage before marriage registrar. Something similar. Parties, they are belonging to different districts. It could be different states also. Okay. Now, certain sacraments are not repeated. You get baptized only one. You get confirmed in the Christian church only one. Okay. So you cannot get rebaptized again and again. Okay. Am I still audible? Hello? 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 Am I still audible? Yeah. Few more minutes and I should be wrapping it up. Okay. Then you have, if they, as I was saying, person could be belonging to different district, different state, still the church does not believe that the person should go through certain sacraments. Sacraments are received only once. Okay. So you cannot receive those sacraments again and again. Okay. And therefore, one denomination may accept the sacrament of some other denomination also. Certain baptisms of certain churches are accepted by certain churches. This is in general. Particularly, one would have to examine whether it is accepted by a certain church or not. Okay. Then you have publication of notice, section 39, that will talk about when one of the intending person intending getting married is a minor. We have already dwelt on this. Okay. So I need not go through it again. Then you have section 41 talking about certificate of notice given and oath made. Oath, what kind of oath is there? We have seen, or rather, we are quite aware of it. No? Oath taking entry in register be challenged in civil court. Anything for that matter is challengeable in the civil courts. Okay. But it is, though we say it's a conclusive proof, or rather, the presumption will be in favor of that it is a good entry, unless you're able to point out it is forged, it is manipulated, they're overwriting and things like that. Yes, it can be challenged, but not at the drop of a hat. You may not succeed. More often than not, you may not succeed in challenging it. Okay. Yeah. So I was talking about section 41, certificate of notice given and oath made. Okay. So then you have oath before issue of certificate. Okay. So one is to appear personally before marriage registrar. He has to make an oath that he believes there is no impediment. Party making oath and theirs, his or her usual place of abode within that district. So all this self-declaration kind of. Okay. So where either each of the parties is a minor, then the consent or those consenting is there. Then the consent or consensus to marriage required by law or that has been obtained. So all those declarations have to be there. Okay. If one can make a petition to High Court to order certificate in less than 14 days, if you are in urgent haste to get married, so you can obtain orders from a High Court. But as we know, the court will not move in very fast to allow solemnizing of such marriage unless there is really a urgency, and if you are able to satisfy the court about the urgency as such. Okay. So consent, I've already told you, consent of father or guardian, all that is there. Okay. So if there is some protest, until that protest is withdrawn, you cannot go ahead, or one to the satisfaction of the marriage registrar, only then you can move ahead. Then you have section 45, we talk about person where consent is necessary, is insane or unjustly withholds consent. Okay. Then what can be done? Okay. So then you go to the district judge. Okay. Or the High Court, depending where you are residing and all that. Calcutta, Madras, Bombay, you go to the High Court. That is there. So remedy of law is not curtailed. Okay, that is always, you're open to always move the court. Petition when marriage registrar refuses certificate. Okay. So you can make a petition. Same point is reiterated here. Okay. And whatever is decided by High Court or District Court is final. We have seen in many law, when we say something is final, they're talking final with regard to the factual aspect of it. But if no remedy is available in law, always there is writ available. Okay. So you can move the apex court also. Yeah. Okay. Then you have 47, which is repeal. Then you talk about 48, petition where register doubts authority of person forbidding. Okay. So the marriage registrar would apply by petition. Okay. If he doubts. Okay. So that provisions are there in 48 as such. Then liability for issuing frivolous protest and certificate. I will move on to the last liability part so that I don't hold you all back for a long time. And then if required, I will come back. Okay. Your small books will give you what? Yeah, divorce lecture we'll touch upon a little later, as I keep saying, because there'll be questions on divorce, and I will address them at the appropriate time. You will have some charts given in some books. We deal with section 66 to 76. Offenses and penalties are given, and if the person is making a false oath or declaration or signing false notice or certificate, then that would attract imprisonment of 3 years. Or if a solemnizing a marriage in case where the person not authorized, then up to 10 years with fine. Then solemnizing a marriage at any time other than those timings, even 6 a.m. and 7 p.m. and all of that, then you have imprisonment of 3 years plus fine. Then knowingly or willfully solemnizing marriage, no, without notice in writing, one of the parties is a minor and all of that, then imprisonment up to 3 years is there. A marriage registrar, if you knowingly and willfully solemnize marriage or issues a certificate without publishing a notice, no, bans what I call BNNS, okay, or solemnizing marriage after the expiry of 2 months, no new notice is given, solemnizes without the order of a competent court, then is in for an imprisonment of 5 years plus fine. Or where is an unlicensed person granting a marriage certificate, pretending that he is a licensed person, then up to 5 years with fine. Then a licensed person without just cause, refusing or willingly neglecting or omitting to perform duties imposed on him by the act, fine up to ₹100, very nominal amount. Or if you destroy or falsify registered books, okay, registered books, up to 3 years plus fine. But very rarely you'll find case law which will give you that person has been saddled with this cost or meted out this imprisonment fine. Okay. So is it compulsory to marry in Christianity? Yes, certainly so, because Christians believe that not to get married is a sin. And for sins, the remedy for a Christian is to approach a priest and admit his sins, and the priest will forgive him in the name of God. But it doesn't mean he can continue to live in that guilt and that offense, a guilt in the eyes of the church, okay, or in that sin. Okay, he is absolved, but not absolved forever. He has to stop that live-in relationship. Okay, the church does not approve live-in relationship as such. Okay, I generally touched upon all these sections, but not all those specifically. But as I said, most of them are procedural in nature. Okay, some case law will tell you only a person who professes the Christian religion comes under the section 68 and all of that. A mere fact that a person is baptized as an infant, generally a person gets baptized, receives the sacrament of getting initiated in the Christian faith at a very early age when he's small, but when he becomes of a reasoned age, say around when he's in 12th standard or so, then he's make a choice whether he has to continue in that faith or not. So mere fact that he's baptized or he's attending a Christian school or he dresses as a Christian, that is not sufficient enough to treat him as such. He has to profess that faith. If you strictly go by these case laws, not many will fall within the criteria of being a Christian as such. Many will not be able to call themselves Christians, because to believe in the set of beliefs and practice those beliefs is really, really difficult. Okay. So again, I said, some Hindu performed a marriage according to Hindu mode between two persons. One of them was a Christian. It was held by Madras High Court that Hindu committed offense. So one Hindu, one Christian. Madras High Court is saying committed offense, but not the Allahabad High Court. Allahabad High Court disagreed. Certainly so. They said if marriage was if the marriage was not a Christian marriage, not an offense under this act. So if it's not a marriage, Christian marriage, then not an offense under it. And rightly so, I feel. Okay. There are quite a few case laws. Okay. Any clarification, because I don't wish to take you to burden you with all the procedure. The oath takes this form kind of, no? I call upon this person here present to witness that I, A and B, in the presence of Almighty God and in the name of our Lord Jesus Christ, to take thee, matlab they'll take the name of the other spouse, to be my lawfully wedded wife, husband, or some words to that effect that will be said. Okay. So a person binds himself to the other person for the rest of his life, and that is considered as a very solemn occasion. And rings are also exchanged as a sign of their, it's a symbolic sign of their fidelity to each other. Okay. And after marriage, they're considered to be one person in the eyes of the church, not in the eyes of law, maybe. Okay. So all those implications it has. Okay. So yeah. Any other things which I think all. So one person will tell the other, I take you to be my lawfully wedded wife as such. Okay. Yeah. Any clarification you'll need? I don't wish to burden you all with going through each and every lecture. Ideally speaking, for your kind of exam that you're approaching, each and every word and letter of every section has to be gone through very minutely and at a very slow pace. But given the kind of task of 76 section to be dealt with in just around 40 minutes or an hour or so, less than an hour maybe, because we somehow technical reason got started late, it would not be possible. So I feel I've done justice to the topic given to me from the point of view of exams as well. If there's any difficulty, my number is 9870370328. I'm in the group as well. You'll always feel free to call me. Ideal time to call me would be around 9 o'clock in the night. Any other time, if I'm free, I'll surely take your call. And to the extent possible, I will satisfy your query on the phone itself. Okay. But don't hesitate to ask me on WhatsApp, in the group, or maybe individually, whatever be the nature of your query. Should I stop here? I don't know. I don't want to tax them and overburden them and go with some kind of indecision. Okay. Certain insights, certain opinions were of my own. But I believe I've been in the church for quite some time. I will not claim myself to be a staunch Christian or very practicing Christian in all its tenets and keeping all its commandments. But surely I'm very much Christian by, not exactly by birth, of course, yes. My 4th generation ancestors were. I'm a native of Mumbai itself, born and brought up in Mumbai. I have a Satbara Uttara, as they say. Somebody has questioned my credential. I have my relatives in the army and all of that. One of my own brothers was ex-Air Force. So we are patriots and we are Christian. This is extra unwarranted and uncalled for. Okay, thank you for this opportunity. Okay,
On behalf of Bar Council of Maharashtra and Goa, I'd like to thank Advocate Prosper D'Souza sir for guiding us and enlightening us on the provisions of Christian law and explain it from the exam point of view. So thank you again for taking time for us from your busy schedule. I would also like to extend my gratitude to the chairman, vice chairman, all the esteemed members of Bar Council of Maharashtra and Goa for organizing this lecture series. I would also like to thank Dr. Uday Varunjikar sir, vice chairman of Bar Council of Maharashtra and Goa, who is the coordinator of this lecture series. Finally, I would like to thank each and every one of you for participating in this lecture series. Thank you so much, all.
thank you for your patient hearing, all of you all. We'll be meeting again. Any clarification, please get back to me. I would love to answer your queries. Yeah, thank you.
Yeah. Thank you, sir.
Take care, all of you all.
We have an announcement for tomorrow's lecture. We have Advocate Zai Vaidya tomorrow. She will be delivering a lecture on latest trends in family law at 5:55 p.m. regular time. Everybody is requested to join, all participants. Thank you so much. Thank you all.
Thank you. God bless all of you all.